final speaker is Judith Bourne. Attorney Bourne was born into a Caribbean family in Brooklyn, New York, and has been a member of NCBL for over 40 years. She co-chaired the organization with Hope Stevens and was active in the earlier international affairs and political affairs task forces. After practicing law as the first Black female lawyer in Charleston, South Carolina, Judith relocated to the US Virgin Islands and has been based there ever since. She worked for a few years as an assistant federal public defender and then established a solo practice based on criminal defense. She provided the legal services needed by the ordinary working people on the island of St. Thomas with its overwhelmingly Black population while continuing her human rights activism. A major focus for her human rights activism has been international with, amongst other things, her participation on the International Commission of Inquiry into the crimes of the repressive and apartheid regimes of Southern Africa, her founding of the Virgin Islands Anti-Apartheid Committee, her participation in the anti-apartheid work of NCBL, her participation in the NCBL support for Free Cuba, for the rights of the Palestinian people, for the Polisario Front, her participation in the IADL International Observer Project for the South African elections, and her work as a lead defense counsel at the International Criminal Tribunal for Rwanda. In the 1980s, Attorney Bourne became involved in a community coalition contesting the rights of a Danish company to the main harbor of St. Thomas, which led to her deep involvement with the issue of the political status of the US Virgin Islands and subsequently of other non-self-governing territories. In addition to local presentations, she's made numerous appearances on the situation in the US Virgin Islands before the 5th Committee of the UN, its Decolonization Committee, and its former subcommittee on small territories, and has participated in a majority of the Decolonization Committee's biannual Caribbean seminars during its 3 decades for the eradication of colonialism, to which she's been invited as an expert. Judith?
Good, thank you very much for that introduction. And I really wish to thank the other presenters who have really rounded out so well the involvement that NCBL has had over the decades and has grounded us now in the present situations, which our section will be addressing in the near future. What I'm going to talk about is something that most people in the US, and especially Black lawyers, are not aware of, and it will seem at times to be rather counterintuitive. First of all, the US currently has 5 colonies: Guam, American Samoa, the Commonwealth of the Northern Mariana Islands, Puerto Rico, and the United States Virgin Islands. Of those 5, 4 of them remain on the United Nations Committee of Decolonization's list of non-self-governing territories. Puerto Rico was removed by the United States in 1952 when it became a Commonwealth, and it was done unilaterally in a way that would not have been condoned 20 years later when former colonies were then on the Decolonization Committee. CNMI, the Commonwealth of the Northern Mariana Islands, which was taken from Japan after World War II and administered by the US under the UN Trusteeship Council, is a US Commonwealth since 1990. That situation is, in a sense, absurd, but very complicated, and I will not be dealing with either CNMI or Puerto Rico in this presentation, because I'm focusing on those colonies which are acknowledged by the US as being non-self-governing territories by their listing on the decolonization list. Now, first of all, I talk about a right to self-determination, which was set forth in the UN Decolonization Declaration. Territories are actually colonies, excuse me, and they're called non-self-governing territories in international law. And they have a right to self-determination. Under UN Resolution 1541-15, an obligation exists under Article 73E of the UN Charter in respect of such territories whose people have not yet attained a full measure of self-government. And that is the language of the resolution. Also, in the language of the resolution, there is a prima facie obligation in respect of a territory which is geographically separate from and is distinct ethnically and or culturally from the country administering it. Such territories have a right to self-determination, and they can attain a full measure of self-government in one of three ways. Those are independence, becoming an independent country, integration with an independent country, and that is not limited to the country which administers it, or to get into a association with an independent country, and that association has to respect the individuality and the cultural characteristics of the territory and its peoples, and retains for the peoples of the territory the freedom to modify the status of that territory through the expression of their will by democratic means and through constitutional processes. That is the language of the resolution. So that is the international law context. Within the US domestic law, the US Constitution, Article 4, Section 3 says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. I would point out here that most people don't recall is that the Constitution itself says that the highest law of the land is the Constitution and the treaties entered into by the United States. They are equal in terms of of being the highest law of the land. Now, there's a gentleman named Neal Ware. He's an American who was originally, I believe, from the Midwest, who moved to Guam with his family as a child. When he turned 18, he found out that he had no senator, no representatives to vote for, and he could not vote for the President of the United States. Apparently that traumatized him, and he has now went to college, went to law school, and has made a career out of essentially trying to make the people and the territories of the colonies the same as the US itself. One of the ways he does that is by lawsuits. Persons born in US colonies, except for American Samoa, have been granted US citizenship by Congress. It is statutory. Persons born in American Samoa are US non-citizen nationals. They can migrate freely to the US. They have all rights not expressly restricted to US citizens. And if they wish, they can become naturalized citizens via a simplified naturalization process. However, there are people from American Samoa who have come into the US and who feel that because they were born under the US flag, they should not have to naturalize. They should automatically be US citizens. So Neal Ware brought a lawsuit in the DC Circuit saying that under the 14th Amendment, which says all persons born or naturalized in the US and subject to the jurisdiction thereof are citizens of the US and of the state wherein they reside. So at issue is whether or not American Samoa is a part of the United States. The district court held that it was not. And the DC Circuit Court affirmed that. And the United States government and an intervener got judgment by summary judgment. They said there was an intervener. The intervener was the government of American Samoa itself. That government intervened on the side of the defendants, on the side of the United States government. What they said was that the social structure of American Samoan society is based on kinship. The land is held communally within that structure, and their local government is also based on that structure. Migrant US citizens who tend to be retired military people are not included in that structure. If American Samoans were generally deemed to be citizens, everyone, all US citizens would have to be treated equally, and the basic structure of American Samoan society could not be maintained. What the circuit court said in their holding, and I quote, at base, appellants who are the, I think it was 2 or 3 American Samoans living in the US, at base, appellants ask that we forcibly impose a compact of citizenship with its concomitant rights, obligations, and implications for cultural identity on a distinct and unincorporated territory of people, in the absence of evidence that a majority of the territory's inhabitants endorse such a tie, and where the territory's democratically elected representatives actively oppose such a compact. We can envision little that is more anomalous under modern standards than the forcible imposition of citizenship against the majoritarian will. Now, Neal Ware probably recognized that this was going to happen, because I think his aim was not to immediately get a decision in favor of his clients, in favor of what he wanted to do. But what he did was go forum shopping. So he then brought another almost identical lawsuit in the district court in Utah. It's the same issue, the same intervener who made the same arguments, but the court there had a totally different analysis. It's not that they took the same things and just said, well, we disagree with that. They analyzed the question very, very differently, and they held for the plaintiffs. That case is now before the 10th Circuit. If the district court is upheld, if the 10th Circuit agrees with the district court that persons born in American Samoa do in fact have birthright citizenship, we would now have a conflict between the circuits on a constitutional issue, which would have to go to the Supreme Court. And of course, the US would take that there. We go to Guam. Guam is a large island. It is the closest US possession to Asia. As you may recall, when there was the brouhaha with North Korea, they said that they were focusing on American territory. That American territory was Guam. More than half of the island of Guam is taken over by the military, with military bases. It was like that before, several years ago, but increased when the Marines were basically kicked out of Okinawa. Most of them were relocated to Guam. The people of Guam, the native people of Guam, are Chamorros, the Chamorro people. And for several decades, they have been actively involved in trying to deal with their status, to deal with their right to self-determination. They developed a Commonwealth Act, which they believed would be an act of self-determination that would come under the free association choice. They sent it up to Washington during the 90s several times. It was consistently opposed by the United States government as giving Guam too much autonomy. Basically, the US government's position was that the Constitution of the US, the territorial clause applied, and that no territory could have any autonomy beyond that. That is still the position that they take with regard to all of their colonies, which, by the way, there was an active conscious choice in the early part of the 20th century by the US government to refer to their colonies as territories rather than as colonies. What the Chamorro people of Guam then did was to authorize a referendum by the Chamorro people and their descendants as to give an advisory opinion as to which of the self-determination choices they wished to pursue. So then they registered, or they allowed all of the Chamorro people and their descendants to register so that they could participate in this referendum. One of the retired military officers from the States attempted to register and was told that he could not do this, that this was only for the Chamorro people. He sued in the federal district court, which held that, in fact, this was an election and the 14th Amendment applied, and that all US citizens had to be allowed to participate. That went to the Ninth Circuit, which affirmed. The Guam government attempted to, or they applied for cert, which was denied. Frankly, I was pleased that the cert was denied, because the arguments that were made on by some volunteer attorneys, a volunteer law firm actually, of Americans, and I don't believe that they made the strongest international law arguments which could be made. I found that the people that have the most difficulty in understanding this actual legal right of self-determination and the application of international law to these issues are American trained lawyers, because they generally have no background in international law, and they tend to be focused on the fact that, as they believe, the Constitution and its amendments are the highest law of the land. Now, at this point, less than half of the population of Guam are Chamorro, because they have this huge population of both active and retired US military. So if they actually had a referendum of all US citizens, you would have a majority of people who would be voting to decide the self-determination of Guam and the Chamorro people who are non-Chamorro and are US citizens. The arguments against the self-determination of the US colonies, the argument that all persons born under the US flag should be considered US citizens, whether they want to be or not, whether their agreement with the US when the colony became under US sovereignty says so or not, and that all referenda, elections, etc., have to be open to all US citizens. Those arguments tend to focus on the insular cases, which are a series of racist decisions that came out of the Supreme Court in the early 20th century. Now, the problem with that is that those cases made a distinction between what they called incorporated territories and non-incorporated or unincorporated territories. The incorporated territories were those territories which then subsequently became US states. And the unincorporated territories were the ones that are now colonies and were always colonies. However, and the basis of it was that those persons in the unincorporated territories were alien races which did not have the background, the intelligence, the culture to deal with the higher standards of US. Now, the problem is that the distinction, I believe there is a legitimate distinction. There are legitimate distinctions to be made between the two territories, the unincorporated territories, the unincorporated territories that have nothing to do with race. But because racism is so associated with those cases, there is now also a movement to try to throw out those cases altogether. But there are, as I said, legitimate distinctions. The differences first, the pre-statehood or incorporated territories were geographically contiguous, going back to the UN resolutions. They're geographically contiguous to the US, and they were, quote, settled by people from the US, and they had the same ethnicities and cultures. We recognize that, of course, prior to their settling, the US government and the US military basically removed the indigenous people from those areas to make them, quote, open for settlement. However, the people who were applying for citizenship, applying to join the Union were people from the United States themselves. With respect to the colonies who are now considered unincorporated, on their acquisition by the US, they already had settled populations. Those populations remain there. And those populations have never had an opportunity to choose what they wanted to be. They have never had an opportunity to choose their status, and the United States has recognized their right of self-determination because the United States placed them on the decolonization list. Now, I believe that these cases, Neal Ware came to the Virgin Islands and then went to Puerto Rico several years ago. And this was before these cases were actually brought. And he made it clear in his presentation, he wasn't talking about American Samoa. He wasn't talking about citizenship. It's positing that he was a civil rights lawyer and that the inhabitants of the non-self-governing territories should have the same rights as those citizens in the US because we are actually a part of the US. I went to that presentation, was prepared to make some comments and assumed that I would be an outlier. There was a relatively small audience, but they were mainly people from, let's say, Virgin Islands families. They weren't a migrant like me, but people whose families had been in the Virgin Islands for some generations. I was quite surprised that there was only one person who spoke in favor of Neal Ware. And that person was a Black person from the US, was a retired US Marshal, and of course, and a Republican, and believes that, of course, this is part of the US. But the people of the Virgin Islands basically said, no, we are Virgin Islanders. We recognize that we have a separate culture. We have a right to decide who we want to be, and basically said, we ain't in that with you. He then went to Puerto Rico, and I understand that he was run out royally because, as we all know, Puerto Ricans have a very strong sense of themselves as a people and as a nation. Now, it's clear to me that these cases, oh, by the way, the name of the organization that Neal Ware founded and runs was first called We the People, and now is called Equally American. But these cases are clearly a first step to undermining the right of self-determination by attempting to integrate the territories into the United States through the United States courts without the consent of the people of the territories. That's not necessarily good for the territories, besides being a violation of their fundamental right to self-determination. First of all, since the territories are not a part of the US, they have no vote in Congress, we also do not pay federal income tax. Income taxes we pay income tax in accordance with the Internal Revenue Code, but the money stays in the territory. And it actually forms a large part of the income for the territorial governments. If we were determined to be a part of the US and then had to send that money to Washington, we'd have to have a whole new layer of taxation, which would be catastrophic. They keep talking about how we don't have the presidential vote, and this is a prime pet peeve of mine. The presidential vote is not a right of US citizens. Actually, the states elect the president through the mechanism of the Electoral College. But because we have every 4 years what is essentially 50 simultaneous state elections together with one capital district election, we think of it as a presidential election. We forget that the Constitution actually gives the states the right to elect, and that initially it was the state legislatures selected, selected the, Kerry.
Yeah, sorry, I hate to interrupt
okay,
you.
Last thing, just the last thing. Okay, that actually the electors were actually selected by state governments, and that the fact that we can all vote now is a matter of state law, not federal law. There's some other things that that are good for the territories because we are not part of the US. People that are here, we're going to send out something to you all. We want you to join the section. We can have these further discussions on these and other matters and take action.